Hello, and welcome to the Genesee Health System Annual Compliance Training. My name is Lisa Shumpert. I'm the Corporate Compliance and Privacy Officer here at Genesee Health System, including the Community Health Center. There are two people in addition to myself in the compliance office. That's Jaquan Taylor, who's the Corporate Compliance Assistant, and Felicia Peoples, who is the Corporate Compliance Auditor. Compliance is located in the Genesee Health System 420 building. That's the Fifth Avenue. You can reach us on the ethics hotline at 762-5288. We are available to answer your call. Just leave a message. We'll return your call as soon as possible. Now this slide, here's a nice overview of the Medicaid Program Administration for Behavioral Health Services. And each level provides a unique role from number one being the federal, number two state, and number three regional, number four county, and then five will be our local contracts. Each play a very valuable role in administering the Medicaid program. Right here, we have a brief overview of the entities and organizations that provide oversight of the entire healthcare industry. I just want to remind everyone about COVID-19 and verbal consent. This is a memo that was released by MDHHS. We had a little bit of room to wiggle for telehealth. And so with our verbal consent, some of the rules have been rescinded. And so this memo is titled Accept Verbal Consent for Services. And if you go down with me in the red section there, the CMHSP and their contract providers can still make use of alternatives to face-to-face encounters to obtain written consent, including but not limited to digital signature, fax, email, or a picture of signed document sent via text or email. Verbal consent may only be given by the person receiving services, and it must be witnessed and documented by the individual other than the individual providing the treatment. So that's the change. And so if you need clarification of that or you have questions, you can call the compliance hotline or you can shoot me an email. This slide is also about the pandemic. And Genesee Health System and the GCHC is offering increased flexibility with respect to telehealth services. This flexibility will enable many of you to continue to provide the much needed and valuable patient care that our consumers and patients need. And obtaining consumer patient verbal consent, this also talks about treating when you're trying to document verbatim in the record. And here's an example. You can read the example for yourself. If you have questions relative to telemedicine, you can direct those to IT in the form of a help ticket and or the corporate compliance program relative to verbal consent. Please be aware that a lot of the rules remain, including ethical treatment and the minimum necessary standards of sharing, as well as public unnecessary disclosure rules. Please be prudent and professional as you work with consumers and others. It's the expectation of GHS that all staff exercise a good faith effort to explaining to consumers and patients their rights to risk relative to telehealth. Consumers should be aware that a data breach or an exposure of protected health information from a telehealth session is possible. However, any bad faith use of telehealth will be subject to enforcement and penalty and could include criminal acts, fraud, identity theft, intentional invasions of privacy, sales of protected information, or violations of professional ethical standards and compliance standards outside of what is deemed reasonable relative to treatment necessity. It is our expectation that you utilize a practice of service that offers as much privacy as is possible in this circumstance. What is compliance? Doing the right thing. So we used to have this program called the Do Right program here at Genesee Health System. And it's something that the state has kind of adopted. And here you can see, basically what does a compliance program look like in terms of behavior. It's a formal program specifying an organization's policies, procedures, and actions within a process to help prevent and detect violations of laws and regulations. But compliance is more than a program within an organization. It's an organization-wide philosophy that guides our decision-making process. And what does that look like for individual behavior? So following the laws, the rules that govern healthcare, being honest, responsible, and ethical, preventing, detecting, and reporting unethical and illegal conduct, preventing, detecting, and reporting fraud, waste, and abuse of federal and state funds. And we have like kind of a little acronym for the culture here of compliance here, GHS. So for compliance, we want to commit to doing the right thing. We want to obey the regulations and policies that apply to your job, make compliance awareness part of your job, practice using the compliance code of conduct as a guide. If in doubt, check it out, meaning just give compliance a call. Attending training sessions as you prescribed, can notify your supervisor of possible wrongdoings, communicate openly and honestly, and then ethics is part of all activities. There are 7 elements of an effective compliance program. 1 is implementing written policies, procedures, and standards of conduct. 2, designating a compliance officer and a compliance committee. Conducting effective training and education, and that's why we're doing what we're doing with the annual training. Developing effective lines of communication, and that would include our hotline. Conducting internal monitoring and auditing. So we look at what you do every day and how you share your information. 6 would be enforcing standards through well-publicized disciplinary guidelines. So there's a sanctioning, aspect of compliance, which if you don't follow the rules, then it could affect your performance, your job, up to and including termination. So it is something to explore when you're looking at the compliance policies and also privacy policies to see, what your requirements are. Responding promptly to detected offenses and undertaking corrective actions. So you would give compliance a call, we look at the wrongdoing, try to maintain confidentiality, take action, corrective action plans. It could involve repayment, notification to outside government agencies, and training. So I mentioned policy to you. I think it's important to look at how is your ethics. The GHS Compliance Code of Conduct should be reviewed annually and can provide guidance relative to the ethics that I spoke of. So here we have the Compliance Code of Conduct and then also your professional code of conduct. And you can kind of go through this later and see what your responsibilities are. I take a look at that policy because it has a lot of good information in there about what you're required to do. The intersection of compliance and ethics. So organizational ethics, what is the role of compliance when it comes to ethics? Supports the organizational efforts in establishing an ethical culture. The Office of the Inspector General, which is what OIG means, a compliance guidance states that one purpose of the compliance program is to increase the likelihood of preventing, identifying, and correcting unlawful and unethical behavior at any early stage. What does that look like? And we kind of went through all of that. We talked about the policies, procedures, the processes, our values, and that very important code of conduct, and trying to be transparent in the things that we do every day and how we communicate. Actual potential conflicts of interest exist that have no safe harbor and should be evaluated by HR and/or compliance. For example, please examine all of the examples in the slide. Additionally, it's important to note that the establishment of a safe harbor, which is an evaluation of an issue before engaging in that activity, safe harbors often will guard against that conflict of interest that I spoke of. At Genesee Health System and Genesee Community Health Center, It's important to provide and obtain information regarding outside employment, potential contracts involving close family members as defined by GHS standards, policy, and finally, to include and or inform your employer where there may be a potential conflict of interest. Laws impacting healthcare. The Deficit Reduction Act of 2005 is a very important law. In addition to this slide, staff should do a complete self-assessment of those things that the average person would view as misconduct. Don't stick your head in the sand. Investigators look for internal controls, things like compliance code of conduct, patient plans of care, good quality care, medical necessity and progress toward recovery, accurate documentation, and best business practices. Your training and understanding of healthcare law, willful ignorance of the law is no excuse. So make sure you're mindful of those conflicts of interest, any billing problems you might have, credentialing and privileging every year, corrective action and prevention where possible, maintaining and taking care of agency property, being diligent about what you need to report. And of course, if you decide to become a whistleblower, meaning that you find something wrong and you want to share it with compliance, we can talk about how the law protects you. There should be no retaliation, no retribution when you report wrongdoing. More laws impacting healthcare. The Federal False Claims Act. This is a federal statute that covers fraud involving any federally funded contract or program, including the Medicaid program. It establishes civil liabilities for certain acts, like knowingly presenting a false claim to the government to get paid, knowing, making, using, or causing to be used a false record of statement to get a false or fraudulent claim paid or approved, conspiring to defraud by getting a false or fraudulent claim allowed to be paid, and knowingly making, using, or causing to be used a false record of statement to conceal, avoid, or decrease an obligation to pay or transmit money or property to the government. Knowingly means you have actual knowledge of it. Acting in deliberate ignorance of the truth or falsity of the information, or acting in reckless disregard of the truth or falsity of that information. No proof of specific intent to defraud is even required. So if you go on a visit to a home and you really didn't do the visit, that would be knowingly attempting to defraud the government. Federal false claims, here's some examples of that: upcoding, billing for unnecessary services, billing for services and items that were not rendered, billing for items or services performed by excluded people, meaning you've been sanctioned. If you've been sanctioned, you can't provide services, failing to repay overpayments within the 60-day requirement, substantiated violations, and then it gets into the civil monetary penalties, which you can go through and read. And so the next slide, which is also about the Federal False Claims Act, gives you a good example. Sally, who's scheduled for 60 minutes psychotherapy with Dr. Smith. Sally arrives for appointment, extremely distraught in crisis. The receptionist immediately is contacted an ambulance, and while waiting for the ambulance, Sally never left the waiting room. Dr. Smith interacted with Sally for only 5 minutes until the ambulance arrived and transported her to a nearby hospital. Dr. Smith had 60 minutes scheduled for Sally and was unable to schedule other consumers during that time. He saw Sally B, even if it was for 5 minutes. Dr. Smith submitted a claim for her for 60 minutes of psychotherapy. The claim was paid out by Medicaid. A month later, as part of a routine Medicaid services audit, Sally's claim was selected as part of the audit sample. And when the auditors contacted Dr. Smith's office to obtain documentation to support the service bill, he instructed his receptionist, the one who called the ambulance, to create a progress note for 60 minutes of psychotherapy furnished to Sally B on the day she went to the hospital. The receptionist created the note. Dr. Smith signed it, dated it, and Sally went to the hospital. The progress note was provided to the auditors to support the bill service. So what's the problem with Sally? So Dr. Smith submitted a claim for her for psychotherapy. He made the receptionist create a note for her that hadn't existed before. And then the progress note was provided to the auditors to support that claim. So that would be considered fraudulent. Problems identified on the previous slide. Medicaid was charged for the 60 minutes. It appears to be intentional fraud. Dr. Smith instructed the receptionist to create a progress note documenting a service not provided, another act of intentional fraud. The receptionist created a note and Dr. Smith signed and backdated. The receptionist and doctor intentionally created, signed, and presented a note to auditors to support a service that was not provided but was billed, falsifying documentation for payment intentionally by both the receptionist and doctor, which is fraud. The Michigan False Claims Act mirrors the Federal False Claims Act, which is an expanded definition. So we have that whole knowingly thing, but we also have times when you should be aware of what is fraud based on your professional training, and including acting in deliberate ignorance of the truth or falsity of that fact. Proof of specific intent to defraud is not required in those circumstances. So allows for constructive knowledge. This means that if the course of conduct reflects a systematic or persistent tendency to cause inaccuracies, then it can be fraud rather than simply a good faith error or mistake. So you can make mistakes, but if according to, if you're a social worker and you should have known that it was wrong, then, the government can hold you accountable. That's all that this slide means. Other applicable laws that you can read through: the Anti-Kickback Act, where healthcare providers and suppliers may not offer, pay, solicit, or receive anything of value in exchange for the referral of patients. The fines are included here. Providers must ensure that no federal funds are used to pay for items and services furnished by any individual who's debarred, suspended, otherwise excluded. So that's why we do the credentialing and privileging. There's some federal exclusions that are imposed if we allow someone who works that's been debarred, things like conviction of a program-related crime, conviction relating to patient abuse, felony conviction related to healthcare fraud, and felony conviction related to controlled substances. So laws impacting other applicable laws are included here. And so you should just review this slide with me and understand that those excluded or finding themselves on the exclusion list may not provide services to Medicaid and Medicare beneficiaries. So you can kind of go through here and see what the issues are, and you can go and look at the exclusion list. And so in the next slide, laws impacting healthcare, these are civil monetary penalties related also in addition, including the Stark Law, which is self-referral. Specifically, a physician may not refer a Medicare or Medicaid patient to an entity providing designated health services if the physician or an immediate family member of the physician has a financial relationship in that entity. In the next slide, so if you decide to become what's called a whistleblower, which is designed to protect you against fraud, but also designed to make sure that there's no retaliation or retribution. Sometimes people sue organizations or file a suit on behalf of the government. It provides a reward in the form of recovery. Anyone initiating this kind of suit may not be discriminated against or retaliated against. And so you would need to be protected if possible. We'd work with you on that. The Michigan statute provides protections also, and then employers may not discharge, threaten, or otherwise discriminate against an employee regarding the employee's compensation, terms, conditions, location, or privileges of employment. In the next slide, we have laws impacting healthcare. And so we kind of went over all of these laws in those last few slides. So offering to pay someone to make referrals to your entity or accepting payment for making referrals violates what law? And then next, the anti-kickback statute. So next we have placing an employee on a corrective action plan because they reported suspected fraud occurring within the agency would be a violation of this law. Whistleblowers Protection Act. And then the next one, using federal funds to pay the salary and benefits of a person who is barred from participating in Medicare and Medicaid would violate this law. Exclusion authorities. And then the next one, identifying that your provider has received an overpayment, but failing to repay that overpayment amount within 60 days of quantifying the amount violates what law? The Federal False Claims Act. And finally, increased federal resources to fight Medicaid fraud, waste, and abuse would be a violation of the Deficit Reduction Act. So this is just a definition of fraud in the next slide. You can review this slide. Compliance means following the rules. It means you understand and comply with all the laws and policies that apply to your program. Everyone, this includes employees, board members, administrators, physicians, students, and volunteers, as well as those whom you do business with, like third-party contractors, have a duty to do the right thing when he or she observes misconduct. In the next slide, we have waste. And waste is the compliance program code of conduct, gives an overview of the rules that GHS expects you to follow in various areas. Make sure in your decisions that it is the right thing to do. If you are not sure, check with your supervisor or compliance. And it has an example here that you can kind of go through to give you an idea of what is waste. And in the next slide, we have abuse. It's a practice that's inconsistent with sound fiscal business and medical practices, basically. It can include submitting claims that do not comply with billing guidelines. So be cautious. Abuse can develop into fraud if there's evidence that the individual knowingly and willfully on purpose conducted the abusive practices. In the next slide, service documentation requirements, Michigan Medicaid Provider Manual requirements, and record keeping. So making sure that your clinical record is sufficiently detailed to allow construction of what happened. All documentation has to be signed and dated by the rendering healthcare professional. That would include making it legible. If a signature is not legible, we can't bill it out. For services that are time specific, according to the procedure code, providers must indicate in the medical record the actual begin time and end time of that particular service. I want to say that again, the actual begin time and end time of the particular service. Progress notes must include goals and objectives of the plan or service addressed, progress, lack thereof toward the desired outcome. So in the medical record, people shouldn't be putting things like the client is doing great and doesn't need any assistance. That means that they probably shouldn't be in the program if they don't need any assistance. So you need to be careful about making sure that you're improving that person's health in every documentation and note that you make. In the next slide, we'll going into confidentiality and privacy and behavioral health records. So you can review this major governing rules. We have HIPAA, the Michigan Mental Health Code, health information technology, which is high tech, and the 42 CFR Part 2 would be substance abuse concerns or substance use disorder records. The next slide. So we have the substance use disorder records. They have their own rules for confidentiality when we're looking at the various ways we treat consumers, and it prohibits even acknowledging an individual as a recipient of services. It requires a very specific detailed release of information. It requires information that is disclosed to include a prohibition on redisclosure. So you have to get permission. You can't just redisclose it like you do in HIPAA. No information regarding a client should be released without a valid 42 CFR Part 2 compliant release of information. And our overall release of information that we have is compliant, but make sure that you're checking that portion that talks about substance use. The next slide, we have mental health records. I kind of brought that up. HIPAA is a federal law that provides privacy and security safeguards. Covered entities must ensure confidentiality, integrity, and availability of all electronic protected health information. The security rule applies to safeguarding electronic protected health information. It requires covered entities to protect against any reasonably anticipated threats or hazards. And we get all that stuff from IT sometimes that, basically says don't share your password, and making sure that, you're not clicking on things you shouldn't be clicking on. And then administrative things, and like I just talked about, and physically limiting access to certain things, and technical would be your encryption. So make sure that you're using that when necessary. And high tech basically just extends all those rules. So in privacy and confidentiality also, these are just like some definitions of stuff. You'll see acronyms and things throughout. The Michigan Mental Health Code is more restrictive than HIPAA. I do want to point that out, and it allows the disclosure of protected health information for treatment, payment, and coordination of care. So that changed a little while ago. And so coordination of care is a more limited disclosure purpose than HIPAA's operations, but it does allow you to coordinate with people sometimes without getting permission from the consumer. So we can talk about that if you have questions about it. Next slide. The Michigan Mental Health Code, you should be familiar with that. It doesn't allow you to share information that you gain in the course of providing mental health treatment to the consumer. It does allow for disclosure of PHI for treatment, payment, and coordination of care. I want to say that again because I get a lot of calls about that. The best practice, always obtain a valid release of information to ensure compliance if you're not sure. Just get a release. If you're not sure about what to do, it doesn't hurt to have a release in there, even if you don't really need one. Next slide. Again, treatment, payment, and healthcare is very important in that whole coordination of care thing. So again, just review this slide. HIV and AIDS information. HIV-related information is confidential, can't be released unless the consumer authorizes disclosure of a statutory exception applies. This confidentiality statute applies to all reports, records, data pertaining to testing, care, treatment, research, and information pertaining to partner counseling and referral services. And so infectious diseases, you can't just share that information. You have to have specific permission. So the consumer must sign a release of information containing a specific statement if the release is to cover HIV-related information in the record before the information can be released. So be very careful about sharing a person's status. If you're not sure, you can give me a call, we'll discuss it, and we can coordinate with, a lot of times I talk to Tracy Malin about infectious disorders and how we share information. The next slide, please. Breach notification. So if a breach occurs when there is an unauthorized acquisition, access, use, or disclosure of protected health information. And depending on the circumstances, a breach can require notice to the client. So if you inappropriately release something, or if there's a mass number of information that's released, I have to notify by sending a letter. Medical records lab type might have been stolen, or posting about a consumer on social media. So don't post about consumers on social media, even if you don't use their name. I get a lot of those reports too. So we do find out about those. So don't do that. You may be frustrated, but don't talk about consumers on social media. Next slide. Common vulnerabilities for release of protected health information. Someone sends an email requesting for information you are not able to verify. Their ability to request this information could be internal or external. Someone sends an email and requests that you click on a link to download information to upgrade your software. All of this can cause viruses and stuff. Someone sends an attachment that you may not be expecting. If you're unsure of what's appropriate action, you can contact the compliance officer and I can forward that to the chief information officer. Thank you. Next slide. So privacy and security, we kind of crisscross and we support each other. And you might get this information again from IT, but these are some things that you should be aware of as it relates to security. I thought I'd throw those in there, but again, just review the slides, make sure that you're taking care of how you access your information and take care of your data. So true or false in behavioral health records? Behavioral health providers cannot ever share my records without my permission. That would be false. The next slide. Protected health information cannot be shared by email. That would also be false. And the next slide. If GHS receives a request from a provider for a patient's most recent treatment plan, mental health only, to assist that provider in appropriately treating the patient, it is acceptable to send the provider the patient's entire record. And that would be false. Next slide. Here are the enforcement bodies that we kind of have to worry about. You'll hear me all the time talk about the Center for Medicaid and Medicare Services, the Office of the Inspector General, the Office of Civil Rights. We work sometimes with the Michigan Office of Civil Rights. The Department of Justice is kind of gotten in there because people are snooping in records and they're really concerned about that. And then people are using identities to enrich themselves. So that's why the Department of Justice is indicated. And the Michigan Attorney General will get involved if there's a healthcare fraud division in charge of investing fraud, waste, and abuse in Michigan Medicaid and Medicare. You can prosecute individual and entities criminally under applicable state laws. Next slide. The Office of the Enforcement Efforts. The Office of Civil Rights began phase 2 HIPAA audits in 2016. And they're focusing on compliance with HIPAA, privacy, security, and breach notifications. So we should take note of that and be careful about, how we're doing things. And so here is a particular theft of information in a mobile device that was compromised hundreds of nursing home residents. And provided management and information services as a business associate to 6 skilled nursing facilities. The total number of individuals affected in this breach was 412. The resolution agreement included a monetary payment of $650,000. I've seen larger amounts, but that's, pretty much how the audit process is going. The next slide. Penalties for non-compliance with HIPAA include knowingly obtaining or disclosing PHI, wrongfully conducting, conduct involves false pretenses, and wrongful conduct involves the intent to sell, transfer, or use for commercial advantage. And that's why I talked about people snooping and enriching themselves by theft of identities. And our population is very vulnerable. And so you'll see this a lot with that population. And the next slide. Reporting responsibilities. It is your right and your responsibility to report actual and suspected compliance violations to the GHS compliance officer, which is myself, Lisa Shumpert, and or Region 10 compliance officer. Both numbers are indicated here. You may not be intimidated, threatened, coerced, discriminated against, or subjected to other retaliatory action for making a good faith report of an actual or suspected violation. I want to thank you for spending this time with me and going over the different responsibilities related to compliance. I hope you have a great year and a great training. See you next time.